Thank you, Mr. Presiding Officer, Mr. Senate President, dear colleagues. I'd just like to take note that so the presiding officer made a ruling. We all know the intention and the duties of the prosecution. We admire your passion in trying to prove your allegations, but we're also all aware that the medium is the message. So during the time of radio and even TV, you make that statement and then it is stricken off the record. It's forgotten. There's no, if I can use the word, mind conditioning. And in fact, when I first became a senator in 2007, talagang hahanapin mo talaga yung records. That's why even here, kapag ka may disagreements and medyo nadala ng emotion, pinapa-strike off the record. At pagka sa labas ng Senate nangyari, naghahamunan ng, you say that here, para magsagutan tayo. So the problem nga with coming up with words especially, and this is for both sides and even for the senator judges, when we use certain words that can be, sa Tagalog, bansag. Binansagan mo na na scam o scammer, binansagan mo na nagnakaw, etc. So personally, I don't mind if you use words that is already in your pleadings or in your articles of impeachment. But of course, it still should come from the witness unless you can frame it in a way that it's not only the dignity of the court. I'm just saying, let's all be aware that when we say it, even if we say withdrawn or even, both sides, kahit sabihin mong withdrawn na to, kahit sabihin mong nice try, etc. We know that that's for the cameras, not just for the court. Diba? Kasi kaming 24, whether we watch it here, we watch it in our cell phone, we watch it inside, kami magde-decide. But we all know we're also trying to convince you, not we. The prosecution and defense is trying to convince the public that either the Vice President or her office or whoever is guilty or innocent. So, yun lang, let's be circumspect without pointing fingers to anyone, both sides. Dahil nga, kapag may certain word na may not only negative but may emotional attachment, magba-viral na yan. And it will really affect the integrity not only of the court but of the decision sa huli. Diba? So, I just like to agree with you and emphasize na, you know, in the future, if you say that nagkamali, let's not kid each other. No? Kahit kaming mga senator judges, nagkakamali din kami. Lalo pag nag-i-interview na or nagkaharap na yung vloggers or yung traditional media. But once masabi mo, it takes a life of its own. Diba? Those words. So we have to really be more circumspect in choosing our words, Mr.
I will allow Attorney May to comment before we proceed with other administrative matters. Yes, Attorney May?
Well, Your Honor, we apologize if sometimes we get carried away by our zeal and our passion, Your Honor. But we at the prosecution, we just want to call a spade a spade.
Within limits, you may.
Yes, Your Honor. But henceforth, to borrow the words of my colleague, Your Honor, we will try to behave.
That will be part of the chair's ruling as well. However, since we're ending at 2:30, Attorney Christine, your cross will proceed tomorrow.
Yes, Your Honor.
And redirect and recross as well. But with the permission of the counsel for the parties, the chair will begin the proceedings tomorrow with its ruling in regard to the August 12 manifestation of Attorney Sheila. So we will begin tomorrow with Attorney Ligutan, giving him his 5 minutes of explanation or not longer than that. The ruling, and then we'll proceed with your cross, Attorney Christine, and then your redirect and recross, if any, by Attorney May and Attorney Christine, respectively. In the meantime, before we adjourn, for the information of Senator Judges, according to the Senate President, we shall convene session at 3 p.m. The court acknowledges the report of the Clerk of Court with respect to the comparison of the acknowledgement receipts and directs the Clerk of Court to furnish a copy of its findings, which the presiding officer initially mentioned last week, to the counsel for the parties as well as the senator judges. So ordered. In relation to the condition of Edward Fajarda, I am in receipt of a report by Dr. Season, the Bureau Director of the Medical and Dental the Medical Dental Bureau, rather, of the Senate, confirming the condition of Mr. Eduardo Fajarda, that he is recommended to have bed rest or to rest for 2 weeks, which began last August 20 and which shall end on September 3. Chair therefore instructs the clerk of court to issue the corresponding subpoena in the subsequent trial date on September 7, 2025 at 10 a.m. The court would also like to note and point out the manifestation yesterday of Attorney Sheila on the 5-day notice rule. When we checked the TSN, just to make sure, the 5-day notice rule applies to witnesses not mentioned in the pretrial order. In regard to witnesses mentioned in the pretrial order, it will not apply, although as the chair already stated yesterday, you still have enough time, Attorney Sheila, because I think you will be able to cross Colonel, who's the first, would you know, Attorney May, who's the first witness, if ever, that you will call a Colonel?
Colonel Boransing, Your Honor.
If at all, the cross-examination of Colonel Boransing will happen on a Monday, so you still have more than enough time to prepare for your cross of the good Colonel. Then Tuesday, then more than enough time. Yes, Attorney Sheila.
Good afternoon, Your Honor.
Good afternoon, ma'am.
Your Honor, I would just like to return to the presiding officer's statement on the application of the 5-day ruling or schedule for the disclosure of the witness. If I may just be clarified, because as far as I recall, this 5-day ruling was a product of the proposal and counter-proposal between the prosecution and defense during the pretrial stage. In fact, when the prosecution submitted its proposal, its written proposal, the initial proposal by the prosecution was only for a 3-day prior period to disclose the witnesses. But we counter-proposed that parties be allowed at least 5 days so that each party may be given ample time to prepare for the examination of the witnesses. And so I'm partly confused, Your Honor, as to the statement that the 5-day rule only applies as to the witnesses who were not disclosed in the pretrial order.
When we checked, counsel, that was the ruling on the chair. In fact, twice. In fact, however, having said that, this situation is unique, as pointed out by the lead prosecutor yesterday, because their intended witness is unavailable because of an ailment, and that they had to fill in with a new witness who is in the pretrial order. And given the amount of time being spent on the witnesses and the interjection of judges, in any case, you will still have your 5 days, in fact, more than 5 days, Attorney Sheila, for this witness.
Yes,
and
sir.
the presiding officer will be conscious of the fact that as much as possible, the witnesses for the following week should be announced by the lead prosecutor on a Wednesday the week before.
Okay.